Hello and welcome to today's webinar. Can I just check that everyone can hear me okay? If you can just quickly type in the chat box to let me know if you can hear us okay, that would be very useful. Fabulous. So welcome to today's webinar, Taking Ownership of GDPR for HR Professionals. It is a 45-minute session, so it's going to be quite swift. We have half an hour to talk to you about some practical HR and data protection elements. We have 15 minutes that we've allowed for questions, so please do ask us any questions as they come along. The webinar is being recorded and it will be available to watch within 48 hours of this session. So anyone that's not able to attend will get a copy of this. I would also like to say that we will be asking you at the end whether or not you are okay for us to contact you as a follow-up on this webinar. Of course, you will have the right to say no if you're not interested. So with that, let's kick on. So I'd like to introduce Sally. She's my co-host today and from Silo Associates. Sally.
Thank you, Kelly. So I'm one of the directors at Silo Associates. We're a HR consultancy based supporting clients in the Thames Valley area. And as a result of supporting organisations, both large and small, we encounter all aspects of HR. So GDPR and how that's embedded in the organisation is sort of very much bread and butter, and that's why we've been collaborating with Kelly. So thank you.
Thank you. And I'm Kelly Peters. I'm one of the co-founders of Data Basics. Some of you will know me. We provide advice, guidance on the fabulousness that is data protection and try to get everybody excited about everyday practical data protection. So that's enough about us. You're here to actually hear about what our views are on practical data protection. So a lot of HR professionals and those that are responsible for HR, whether you're an operations director, a HR business partner, you'll have a lot of information at your hands and you will be concerned about the welfare of the data that you're responsible for, whether it be your employees, volunteers, candidates. And even more so now that GDPR has come into force. You will be, I'm sure, very familiar with the fact that last year, pre-25th of May, there was an awful lot of panic about compliance with data protection and about the financial penalties that could be imposed on a company should they not be compliant. So it was very much a tick box exercise for a number of organisations because it was about compliance. As HR professionals, you'll certainly be confident about the fact that cultural change takes a lot of time. So where we are talking about new ways of working or raising people's awareness of new policies and procedures, just having a policy isn't enough. It takes time. That's why people and data protection in the HR function is so fundamental to data protection and its role. That, however, does not mean that you are the only department in an organisation that is responsible for data protection. One of the things that we are very keen is to recognise the importance of data protection is everyone's responsibility. So our view is very much that data protection is a multidisciplinary exercise. It will involve IT, it will involve HR, but it may also involve your finance team. It will also involve your sales and marketing reps. If you work in a charity or you are a franchise, it will involve other departments that are responsible for different types of personal data. It isn't just HR. So one of the questions we really want teams to consider is how often do you bring up data protection in a team meeting or raise its profile with colleagues? Because I think it's through team meetings and through executive team meetings, if you as a HR professional sit on the executive board, are making other team members aware that you need support and help from other departments. It is not just employee and candidate information that is potentially at risk. So one of the very first practical things that we would suggest that you do, if you're not already doing, is in team meetings, in senior management meetings, at the executive board, have a topic about data protection on it. It doesn't have to be long, but only through regular conversation about data protection can we genuinely change people's perception of it just being a tick box exercise. And you're able then to share the fact that it is everybody's responsibility. You, as the HR professional, cannot do it by yourself or in isolation.
And we know from talking to our clients that that won't just be about satisfying compliance, it can also be about learning from experience. So GDPR covers data breaches. So just by having that on an agenda and learning from how something has been handled will help you going forward in how you would handle other similar situations. So,
absolutely. So a story that recently hit the press, and the reason why I wanted to raise it now is that a lot of people think about data protection issues as being an external force that affects an organisation. And I'm sure as HR, you're probably fully aware that a lot of risks are internal to the organisation, typically from individuals that are unhappy, whether in their personal life or whether just unhappy as where their work is going. The example here is that Miss Bonafide, her details were accessed by her ex-partner. So her ex-partner had access to EE databases. He was able to change the direction of where her text messages were sent. He had access to all of her information in terms of bank account details. And while she did raise it a concern with the organisation didn't take it as seriously at first. It was only until she raised the issue with the police did the company take it forward and look at, and they acknowledged that the problem hadn't been fully addressed to their policies. Now, for me, the points are, whilst it's a privilege to access personal data, you can't use it for your own reasons. Anyone that works in the healthcare sector, there are always stories about administrators or nurses that have accessed a file because they are interested in what's going on in a family member or a neighbour. It's got nothing to do with their day job. They were just inquisitive. It is worth pointing out that it is illegal for individuals to access personal data without authorization. So whilst they have the ability to access the data as part of their job, if what they're doing has no relation to the job, then it is illegal, and staff need to be aware of that. And companies have to ensure that data that is managed securely and protected, and as I say here, against unauthorized or unlawful processing, and against accidental loss, destruction, or damage. So my question to everyone on the webinar is, how would you know if a member of staff who was unhappy was accessing information that they shouldn't do? And it comes back to that point where I'm talking about it's a multidisciplinary team. So how would your IT team tell you? Would it be someone in sales team or marketing that says there's something very odd going on, and they approach you about how would you handle that? And this isn't the first case, and I'm sure it won't be the last case. So the learning from this is, what would you do in this scenario if you were faced with this? Hopefully it wouldn't be, oh, it can't be the case, this is not happening, and ignoring the poor individual in this incident. And obviously we've got the Morrison's case, which is a very big case that is going through the courts at the moment, which was again a very unhappy member of staff who then posted an awful lot of information about staff onto the web. So that was a little scary, but I think there's ways that we can ensure good data protection practice and accountability through regular staff training. I'm very passionate about educating individuals at all levels within the organisation, because whether it be the receptionist or a member of your marketing team or a member of the sales team or even an executive director, is, do they know what their role is in terms of data protection? Do they understand their responsibilities? It is for everyone to play their part. I do believe that there should be adequate training, and there are different levels of training. You could have basic awareness, just like you do when you test your fire drill. You get people to follow the procedure. It's only through routine do they understand what they need to do. But then there are specific data protection training that could be useful in terms of subject access requests, which could come from clients as well as they can come from employees. Data breaches, there will be the raising of awareness of when a breach happens, but in terms of actually running the scenario of what are all the steps that an organisation would need to follow, including do they notify the information commissioner or not, how would people know how to follow that without training? Yes, you can have a policy, but the training supports the policy and it then changes the culture because people are aware of what is going on. So for me, it's the question for you to go back to your teams, to your organisation is how often do you provide data protection training? And through this, identify your risks. What are the biggest risks of financial and emotional harm with the data that you're processing? I'm very big on why not test it? Very much like your fire drill, test how you would handle a subject access request, test how you would handle a data protection breach, because through testing, you're better prepared. The reason I would talk about that previous slide was because, again, an example of there was a housing developer was fined because they ignored a subject access request. Now, the individual had the absolute right to have access to the information. As you'll know, it's one of the requirements under the GDPR, the right to access. The firm ignored that request. The individual then quite rightly complained to the information commissioner about this. And it was the information commissioner found in favour of the individual and then took the housing developer to court. Now, they were fined a minimum amount of money, but they were still taken to the magistrate's court. The lesson that we learned from this is if they couldn't recognise a subject access request, they were never going to be able to respond to it. So for you as an organisation, how would you know that you've received a subject access request? Bear in mind, that can come through your social media channels, it could come through your email, it could come through someone walking into the office to say, I want access to my information, or it could come over the phone. What would your approach be? Would you recognise that it's a subject access request? And then, most importantly, would your staff know where to go, whether it be a request that's come from an individual, that's an employee, or whether it's come from an external customer or client? So it is important to take these seriously because there can be consequences and potential loss of trust if these requests are not addressed.
So now it turns to me to actually for you to sort of think and go back to what you've already put in place within your organisations. So having those clear recruitment employment policies are absolutely essential, and that will be your bedrock within your organisation. But have you sort of taken time to think about how transparent that information is within your employee privacy policy and what you're actually communicating to those new and prospective employees? I suspect for some organisations you may have taken a template document and readily used that to ensure that you were compliant, but actually how much information was put in there in the first place. So a really good example of that would be what you say about the sharing of information to third parties. You may have a very legitimate reason under the GDPR requirements for passing that information on to accountancy firm ABC to process your payroll, for example. But actually to be transparent is bedrock as part of GDPR regulations. So for us, best practice is to stipulate that it is accountancy practice ABC, or if you're referring to a legal company for advice, again, that you would specify that so that people would know that that was the case and that they'd be agreeing to that when they first joined you. And as I said, thinking about what you're sharing and saying you'll do to prospective candidates so that they are aware that you will be retaining their information, but for only a finite period. And again, that's really, really key. So, one thing that we wanted for you to take away from this was to go back, look at what you actually have put in place. Think about how that relates to your contracts of employment as well, because you'll stipulate within those certain clauses saying refer to the policy, refer to the company privacy policy. So really make sure that those two things are very joined up. And also take into account how much perhaps you cover as part of induction and then ongoing training, as Kelly's highlighted. So, really important for you to have a look at that. So that's the sort of starter, thinking in terms of recruitment and those practices when you're first looking at people and when they're joining the organisation. Now we want to both of us share some tips with you around creating some best practice exit checklists. So Kelly, perhaps if you sort of turn to this first.
So what I've typically found is that organisations have really robust recruitment processes. They know the information they need to collect at the point of recruitment. They know what information they are going to have at the point of induction. But when it comes to the individual departing, they may have the option of an exit interview, but there is not the exit checklist. So things such as, has all the equipment that the individual has access to, whether it be a laptop or a work mobile phone, been handed back? Have company personal data been deleted from bring your own devices? So a lot of you may permit your staff to use their own device for work purposes. Now, whilst you may have a bring your own device policy, what assurances do you have when that individual has left that the information that relates to your company has been removed from that mobile device? And the reason this is so important is because I've recently had a conversation with somebody where we talked about they suspected that a member of staff that was leaving, they were leaving to go to a competitor, was downloading confidential information from internal databases to take with them to the next organisation. And the question was, Kelly, what can we do under from a data protection perspective? And I'll touch on that in the next slide. But one of the points I went back to is, how did you identify this? And it was only through IT that they noticed something that was unsuspected, that they raised it. It wasn't part of a checklist. So think about equipment and where the data is on personal devices. And also think, if you allow people to work remotely on their own computers from home, is there any possibility that the data they have access to is stored on their local computers? If that is the case, again, you want some reassurance from the member of staff that's leaving that they have deleted that information. If you then have that in writing, you can then put that in your file for the employee so that you've done everything, your due diligence, as you could do.
And this takes us on quite nicely then to reminding those employees, as they said to you, I'm resigning, reminding them of their legal duty to keep that information confidential. And sometimes, it's in those resignation acceptance letters, it's reminding, as you would around your IP and protecting your business, you'd be reminding them of the need to not be sharing confidential information, and that applies to after they've left, because I think people need to be reminded of that, and your contract should reflect that their duty of confidentiality continues beyond them leaving the organisation. Now, the part of that we know isn't just the fact that that data is confidential and commercially sensitive, as Kelly's described, but some of this is also about reputational damage that can be caused equally as a result of this. So this takes me on to the sort of last bullet point about not forgetting to remove rights to other things when someone leaves, because if you enable them to still have the permissions, then they can send out information and messages on behalf of the company, which can in turn, as I've said, cause that sort of damage that you just do not want. So removing rights to social media passwords can really easily be forgotten. But think about, you may have a company LinkedIn account. They may have reference in their own LinkedIn statement, you know, that you need to think about how they use their own accounts around that. A company Facebook account, all of those accounts that you put in place. I think organisations readily will think, right, I'll remove rights and access to sending emails out, but it's the social media aspect that can be forgotten. Access to company database and files is also an interesting one. You will think about removing the access, but there may be for more senior people in the organisation the fact that they will have passwords to those systems. So make sure in those situations that you change the password so you know it removes that ability. And you may have to factor into this, you know, if we're talking about an exit process that was a result of a very serious investigation, you know, is there something that you might have to consider as part of that process? Nonetheless, I think all of these things that we've put here together as a checklist are about actually, you know, helping you as a business. This is good practice advice. This is not about scaring you around some of those trickier employment matters. This is just good, robust management of your information and data. So, yeah.
Absolutely, and I think the reality is in today, people have access to so much information. It's sometimes hard for us to reconcile just how much access they have. And what we want to do is when someone leaves the organisation, whether it be in a positive way or in a very unhappy situation, that as an organisation you have protected yourself as best as possible in terms of removing that access or future issues, because information has not been deleted from devices that we've discussed above. And the only reason I raise it is because whenever I typically do an audit, most organizations don't have an exit strategy such as this. So keeping data for as long as possible. I am a little nerdy when it comes to data, and you know, I love what it can tell us, but I've been in a number of situations where information is being stored for far too long. And the prime example is, as HR professionals, you will have a lot of information at your fingertips, is the fabulous CV. Now, when we are recruiting, you will potentially get a large volume of CVs. A number of those individuals will be unsuccessful, but their CV will have been passed to multiple people in your organisation as part of the recruitment campaign and being part of the interview panel and the selection process. Now, when I talk to people and they will say to me, Kelly, we only hold information for a year for CVs for unsuccessful candidates, I'm like, fantastic. Then there'll be other people who are like, oh, well, we've never really considered it and we're uncertain as to if we've ever done anything about it at all. So what I would ask people is, if you were to look at your email system and you were simply to type in the word CV, how many CVs would you find? And more importantly, how far back would they go? Because we need to remember that unsuccessful candidates have the right to put in a subject access request as anyone else. And if we're holding on to CVs that are 10 years old, they are no longer relevant, we shouldn't be storing that data. So it's all well and good having a retention policy, but practically, how do we enforce that from a HR perspective? And obviously, it's not just for CVs. There'll be when an employee leaves, how long would you hold those files for? And what happens when you reach that retention period? Will your software systems prompt you to say, this employee left 7 years ago? Your policy is 7 years on from the employee's departure, you will delete their information. Does your system support that? Is that a conversation you need to have with your software supplier? Is it a conversation you need to have with your IT team? So think about, whilst you have a retention policy, how do you actually apply that to your everyday HR data management? So think about what your procedures are, and then most importantly, what do you do when you've reached the end of that retention period? How are you shredding that information? How are you deleting it from the actual physical devices? Because you cannot hold information forever. You will need to have a retention policy. If you don't have a retention policy, one of the practical things I would suggest that you do is to go away and think what information you should retain and for how long. And as HR professionals, you can go to the a CIPD website, which will give you information on professional development and how long you can hold information for from a HR perspective.
And just from a sort of a practical, it may be that you already have some of the answer to some of this. You know, if you're using any HRM system, software or applicant tracking system, you know, could that enable access of CVs by recruiting managers and then avoid the need to email? And it may be then it's just about training the managers to feel better able or perhaps more likely to log in and access the CVs through that route, and it keeps everything in one place for you. And certainly, you know, HR software is something that we find very helpful for our clients, because, you know, it's automatically the software provider has to ensure the system's GDPR compliant and can auto archive those records for you. So, you know, if you can find a quick win and save yourself time, it might be worth just having a look there too.
So we've talked about retention. We've talked about, you know, what information you should be telling people you're holding within your staff, but we need to appreciate that a data breach can happen on any given day. Any organisation that tells me they've never had a data protection breach, I would have to question and say, are you telling me that no one has accidentally sent an email with an attachment to the wrong person? And if they say, well, yes, then to me, that is a data breach. It may not need to be reported to the Information Commissioner, but you have inadvertently sent information to the wrong person. So one of the things I really want organisations to consider is, how can we make it, or staff feel quite comfortable in just putting their hand up and saying, I've made a mistake, I've accidentally sent this, but they not only do they put their hand up and they feel comfortable in doing that, they know who to tell in the organisation. So I think only through that reporting and learning are you able to potentially prevent a future more significant data protection breach. And one of the things that we regularly tell some of our customers to do is, why don't you look at the ICO website, look at one of the breaches that have recently happened. So for example, let's use the EE one that I talked about today. How would you handle that? If that happened to you, what would your approach be? If you lost a USB stick, like the individual from Heathrow Airport that had the Queen's movements on it, what would your approach to that be? So learn from other people's mistakes and share that learning with your staff. If you do have breaches, bring it up in the team meetings and say, this is not about naming and shaming. This is saying, this happened, this is what we did about it, and this is what we can learn from that. So there is a genuine culture of, we've made a mistake, we want you to tell about it. Because the worst thing that you want to have is for someone external to phone you up and say, I think you've had a breach. You want to be in control of the breach situation. So do learn from near misses, because I think they are your best way of introducing change. The case I talked about earlier was what would you do in the instance of a member of staff who is taking information from you and they are taking it to another organisation. This is an individual that was taken to court. They were taken to court under the Data Protection Act of 1998. It absolutely exists under the 2018 regulation. An individual within an organisation can be prosecuted where they are using information inappropriately. So this, the defendant took information, was a recruitment consultant from her old employer to a new employer. Now, not everyone does that, but there are a number of incidences where people turn up to a new job and say, I've got a database.
On a memory stick,
yeah.
Yes, I've had that.
And some of you may have had that as well. And the question is, how did they get that? Do they have the right permissions to do so? So this is very much about reminding staff that whilst HR may be responsible for the data protection policy, and as an organisation, you are looking at ways of preventing breaches, you are looking at ways of responding to subject access requests. An individual that is negligent within the regulation can just as well be penalised and, you know, taken to court and found guilty, which then has a massive impact on them.
And also think about what you say in your policies about people taking information to work from home, for example. You know, because if you don't want that to happen, then that needs to be very clear, or if you allow for that to happen, under what circumstances that's allowed. So that if you suspect somebody is taking your data whilst being employed, so different to Rebecca, who did this subsequent to leaving, but if you think somebody's doing this while they're working with you, then you will be relying on those policies to take, you know, effectively disciplinary action, as opposed to them relying on the fact that they didn't understand those rules, and that would be their defence. So again, looking back to your policies. Yeah.
So in summary, there are a few things that we think you should think about. So there are the need to know. So data protection applies to everybody. It's not just a HR responsibility, and regular training of data protection across the organisation is essential. We feel that there are a number of good to know. So encourage staff to understand that owning up to a mistake is okay. You can learn from these, and you can implement and make changes. And the no-nos, as much as data protection may not be the most exciting and thrilling subject, people shouldn't be afraid to ask questions. If there are elements of the regulation that are uncertain, or there are things that you're not sure how they apply to you, it is about being able to ask the question either within the organisation or externally. So our quick 30-second commercial before we open the floor to questions is, we're presenting this because both of us provide different types of support. So for data basics, if you are looking for external audits or training, or you feel that actually having someone come in that can be the bad cop to your good cop, then we can do that. We can provide, and there are some of you that have experienced my training, can introduce some fun to data protection training.
And at Silo Associates, I kind of referred to the things that you would expect: policies, advice may be very specific HR and legal advice with some challenges, but ensuring you've got the right fundamentals with contracts. But outside of that, so definitely Kelly can offer the very specific training, but I would also add in that we can provide leadership training, because maybe if you think for the organisation, this is about the values that we set and how that's communicated, you might say to yourself, well, actually, do our leaders have those softer skills to enable that to happen? We're also able to help with that. I mean, the SYLO is Sort Your Life Out. We take a very practical approach, just in the way that Kelly does. So there can be a really nice synergy between the training that we'd offer at that leadership level to the very specific training that Data Basics offers so well. Yeah.
So now it's over to you. So we have roughly 12 minutes. So if you have any questions, please now use the type box to ask us any questions that you may have. If there's anything that you're uncertain about what we've covered, please do pop it in the text box, and we will take the next 10 minutes to respond. So one of the questions we've got is, could we go over again what you said about central location of CVs to keep them out of inboxes? Okay. So I'll hand that to Sally.
So I covered the point where, for an organisation, particularly if you handle a lot of recruitment, you may want to take advantage of some specific HR software to help you with that. So you've got HR systems that have recruitment modules. You have what's called applicant tracking systems, but they're essentially just a database for storing and processing CVs. And they send out, you can send out from them emails to the candidates, and equally a manager can log in and access CVs from there. So it just keeps it all in one place and avoids all of the email communication with CVs. So I hope that helps.
So whilst we're waiting for any more questions that you may have, something that I typically get asked is what should be in a, I've got a question before I jump ahead. So we use Google Drive and share with people who need to see them, is there anything we need to do? I think the important fact about using anything such as Google Drive or Office 365 is that once you've set up that shared drive, is you need to remember who has access to that shared drive. So should that individual leave, you want to remove the access for it. You may want to put in a timescale over the shared drive in terms of this will only be a shared drive for a maximum of a year, and then you will close that down, because what you don't want is multiple shared drives out there forever. So think about Dropbox as well. So for me is, what's the purpose of the shared drive? Who has access to the shared drive? How long do you need that shared drive to be used for? And then when people leave, make a note to revoke their access to that shared drive.
And I don't know if this touches on another question, but when you're looking at shared drives, throughout all of this presentation, we've talked about employees, but a lot of this would apply to contractors as well. So if you've created a shared drive for a contractor to do work for the company, equally think the same when they leave too, that you remove those rights.
Okay, so the question we have is, how do you deal with a contractor that is using his own PC and has dealt with various information and has now left in a very swift way? So we have asked if he's removed the information from the laptop, but he hasn't replied. I think what you want to be able to do is, if you've asked him and you haven't had a response, I think it's whether or not you're going to get any response. Is there any of the information that he still has access to? What's currently on his PC? I would suggest not just emailing, but writing to him as well and reminding him of any contract that you had in place that states the information that you're processing on behalf of us as a company belongs to us, and you have to remove it and ask for a response, because then you have the audit trail of that conversation that you're having. There's little you can do if he doesn't respond because it's his technology. But the other thing I would say is, in the future, where you do have contractors, is in that contract agreement that you have, be very clear about what their responsibilities are under data protection, and that you want that reassurance that they have removed your critical information from their systems.
We've helped a number of clients produce those contract agreements, and what we've found to be really important is going through those contracts when they're first engaged, because if there feels any informality, then people may not recognise the legal basis on which they're being engaged, particularly with contractors, because it's very easy to fall into quite a loose relationship. So just as you would onboard an employee, you onboard, you go through those steps with the contractors when they're first joining you. And when Kelly was talking about writing to them, I found writing to them, explaining the legal consequences, often can help too. So just as we've talked about that before, employees do the same.
Perfect. So the question that we had is, are there any regulations that we need to keep in mind when we share employee data outside of the EU? Well, the GDPR will apply regardless, because you are looking at EU citizen information. So what you need to consider where you are sharing information outside of the European Union is, does the country that you're sharing the information with, so if there, for example, are servers that are based in the US, is that company registered with Privacy Shield, which recognises European law? How is that company assured you about the information that's being protected? But as part of your privacy notice with your staff, you'll need to tell people why you're sharing that information, and the transfer of data is, what are you doing it based on consent because you're sharing their information outside of the EU? Are you doing it as part of the performance of a contract? So the company in the non-EU company is fulfilling a contract for you that processes personal data. So notify your employees to let them know. And I would definitely check before you share any information with a non-EU country that they are compliant and they recognise what their responsibilities are under the GDPR. The other question that we have is, do we register with the ICO? My answer to that was, even though you're only processing employee data, you will be processing potentially sensitive information as well. such as potentially medical records, or you may be doing checks in terms of financial checks, or you're doing any kind of working with vulnerable adults. So for me, you can go to the ICO website if you want the reassurance that you should be registered. Go to the ICO website and do the quick 5-minute questionnaire of what is your fee and should you be paying that fee. Okay. WhatsApp is a really, really interesting scenario. I'm not the world's biggest fan of WhatsApp for work environments, but I appreciate that it is being used from to communicate about work issues. Ex-employees absolutely need to be responsible. So the question would have to be, who administers that WhatsApp group, and the administrator of that WhatsApp group should remove that individual from that conversation. And my preference would be, if there are other ways of communicating, try not to use WhatsApp. Okay, so if you don't have control over the WhatsApp group, I would suggest that all the other members of staff that you know are aware of that group is that they exit the group so that they are no longer part of the WhatsApp conversation.
So the question now is in relation to the contractors, is there a robust template contract that can be used? So there will be organisations like the FSB, if you're members of them, that you could access a template. It will be a fairly standard template. It may be if you've got some very specific requirements and needs that you may then want to access some particular legal advice over that, you know, because robust will be as detailed as it needs to be for your business, is my experience. And just in the same way you've got template for an employee contract, you will often find companies need to bespoke them for their own requirements. So I mean, if you are a member of an organisation with templates, then go to them, then test out if they actually do address all of the issues you would expect and require of your contractors. You know, for example, when they leave, we expect you to return property. Check and see what it says there. If they don't have those clauses, then turn to advice, and that's certainly something we would help with.
Okay, so we've got 2 more minutes. If there are any more questions, please do let us know. And if there is not, for those of you that are on the call that don't have any questions, could I ask that in the text box you indicate whether or not you would be happy for Sally and myself to follow up with you following on from this webinar to talk about any issues that you may have. So just a yes or a no. If you say no, we will absolutely respect the fact that we will not contact you. Thank you very much. You will have access to the webinar. It will be online within the next 2 days, should you want to recap what Sally and I have said. So I hope it's been very useful. Thank you very much for giving up 45 minutes of your lunchtime to join Sally and I. For those that have said yes, we will be in touch within the next week. So thank you very much. And we'll let you go.
Thank you, and a goodbye from myself. Enjoy your weekend.
Yeah.
Thank you.
Thank you.